Pensions are something that are often forgotten about or neglected when talking about a financial settlement following a divorce. They're an absolutely crucial part of the matrimonial assets. They'll often be the biggest or second biggest asset in proceedings, and they shouldn't be forgotten about. Pensions are commonly dealt with by way of a pension sharing order. That's when the total value of the pensions are assessed and a percentage of one of the pensions is transferred to the other party to ensure that there's a fairness in division. To calculate a pension sharing order, the total value of the pension assets will have to be added up, and then they will be assessed to see what percentage is required to be transferred from one party to another. This is usually dealt with by way of what's called cash equivalent values. However, you need to be cautious because certain pensions have cash equivalent values that aren't actually related to their value in real life, so careful, independent advice needs to be taken. Commonly in financial negotiations, instead of a pension sharing order, a party will choose that they will forego their share of a pension and instead retain more of the other assets. For example, they might want to retain the family home and leave the other party with more of the pension assets. This is a case that needs to be talked about and thought about very carefully with some independent financial advice to make sure that you're making the right decision for you, both in the short and the long term. A family lawyer can help with pensions by looking at the overall value of the pension assets, seeking advice from independent actuaries or financial advisors where needed, and looking to negotiate an overall settlement that provides a fair outcome for both you and your spouse.